I'd like to thank all of you for coming to what is going to be a splendid event. It's spectacular to see this packed room, and hello to the untold numbers of people who are watching this live over the internet. My name is Adam Mossoff. I'm a professor of law at George Mason University School of Law, and I'm the co-director of academic programs and a senior scholar at the Center for the Protection of Intellectual Property. Today, we have three very distinguished judges serving as panelists to discuss whether the patent system is working or broken. And their discussion will be moderated by an equally distinguished judge. Now, this is certainly the first event of its kind, and as I said, it is co-sponsored by the Center for the Protection of Intellectual Property and by the Federal Society. Now, information on both of these organizations is available at their websites. Or for those of you who prefer pre-internet forms of communication and information transmission, there's information in dead tree format out on the table in the hallway. Now, our panelists and moderator are all very well known, and deservedly so, and they each have many achievements, awards, and accolades. I mean, it would likely take the entire panel time for me to read all of their full bios. But I think that you would rather we prefer that we spend the time actually talking about patent policy and the issues and concerns of the patent system today. So we're going to keep their bios very short and sweet. In order of their opening remarks today, our panelists are Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit, who unfortunately could not be here due to some last-minute changes in his travel, so that we thankfully embrace technology and have him on video. Next will be Judge Arthur Gagliarza, former circuit judge of the U.S. Court of Appeals for the Federal Circuit. We have then Judge Paul Michel, former chief judge of the U.S. Court of Appeals for the Federal Circuit. And their moderator is Judge Douglas Ginsburg, former chief judge of the U.S. Court of Appeals for the D.C. Circuit, and I must say also a professor of law at George Mason University School of Law, my home institution and the home of the Center for the Protection of Intellectual Property. Now, all of these individuals went to excellent colleges, they attended prestigious law schools, and then they became judges. So for those of you who need more information, you can easily find it by Googling their names. And big surprise, they all of them even have Wikipedia pages, although their information beware. So now we intend for today's event to be truly a discussion. And so each of the judges will provide very brief opening remarks of approximately 5 minutes each. And then Judge Ginsburg will begin a moderated question and answer session among and between the panelists. At appropriate times, questions from the audience may be considered, but at a minimum, there will be time dedicated to questions from the audience for the last 30 minutes or so of the program. So without much further ado, I'm happy to turn the mic over to Judge Ginsburg, who will run the program from here. So thank you.
Well, at this stage, it's rather self-running. We're going to hear, as you said, from Judge Posner first. Judge Posner has written extensively in recent years about problems in the patent system. He's tried a number of patent cases and tried to try a larger number, but they keep settling. And then we'll turn to our next panelist. Dick, it's all yours. 5 minutes.
Okay, thanks, Doug. So I'll be very brief, as we're supposed to be. So there are conceptual issues involving our patent system, and there are practical issues, and I'll speak about both of them. So on the conceptual front, there just is no good reason, in my opinion, why one would give a monopoly to an inventor unless, because of very heavy upfront costs, very low cost of copy, and so on, the invention wouldn't be made if you didn't give the inventor a monopoly that would enable him to recoup his upfront costs. And these conditions for the grant of a patent are very rarely encountered in the real world. There are industries like pharmaceutical drugs where this is a common problem, very heavy upfront costs, low manufacturing costs that would enable copiers to charge a remunerative price for them that would make it impossible for the inventor to recoup his costs. In most industries, the products do not have a long shelf life, or they're cheap to invent, or there are advantages to being first that give you an opportunity to recoup your costs because maybe consumers have a strong identification with your brand and prefer it even after there are cheaper substitutes, or there's a learning curve and you start moving down your learning curve faster than anybody else because you were first, so your costs are always lower than those of competitors. So it's very strange that we should have a uniform 20-year, patent term, with some exceptions like the longer term for pharmaceuticals, when for most inventions there just isn't a need for that monopoly. So it's astonishing. I read just the other day there are 400,000 software patents in force, unexpired, even though most software patents are on relatively minor components of devices, and they're invented by teams of salaried engineers, no tremendous upfront cost, and they're quickly superseded because of the rapidity of technological change. So I think we have too many patents. And as a result, we have patent thickets, we have the patent trolls, we have patent races. Patent races aren't entirely a bad thing because they do accelerate invention. But they also can be extremely wasteful because they have a bunch of companies all expending resources which are duplicative in an effort to be first. The practical issues are numerous, and the way to see this most easily is to look at the patent adjudication system from the bottom, the Patent and Trademark Office to the top, the Supreme Court. All those levels, I think, do badly. Not always badly, but badly. PTO, understaffed, under-resourced, great variance in quality of the examiners, very slow in issuing patents, certainly not a competent enough administrative agency to warrant the presumption of validity which attaches to an examiner's grant of a patent. In the case of software patents in particular, there are great difficulties in searching because of lack of a uniform vocabulary. It's difficult to search the patent records in order to find the software patents that you might be overlapping. There's the ITC. I don't know a great deal about it, except that it overlaps and often is in conflict with district courts, have parallel litigation pending. Then there are district courts where you have a number of problems. Judges and jurors, for the most part, are not comfortable with technology. Jurors and many judges do not understand patent law jargon, which is pervasive. There's a lack of firm control over pretrial discovery by judges. Failure to set tight deadlines. There are incomprehensible jury instructions incorporating reams of patent law and technological jargon. There is a failure by most district judges to utilize court-appointed experts, which I think are essential in order to give a judge and jury some balanced, neutral picture of the issues. The remedy situation in patent adjudication is very bad. Overuse of injunctions, arbitrary computation of damages, poor remedy experts who really don't have expertise. Then we have the trolls, of course, and the trolls now being augmented by the new hedge funds for financing litigation. They will be a big boon to the trolls, although that's not the only thing they do by any means. the very long patent terms we have, the 20 years to 25 years, which I am critical of, they complicate litigation by increasing the amount of prior art that has to be studied. And then there's the Federal Circuit. Unfortunately, I think from the beginning, considered itself to be the promoter of the patent system, because the Federal Circuit was born in the early 80s because of a terrible mistake, a belief that the United States was being outclassed by Japan in technology, and we had to fight back with more patent protection. So the Federal Circuit became the promoter of patents, big surge, number of patents issued and involved in litigation, so on. We see the Federal Circuit has trouble getting its act together. We have this remarkable case of last week, our CLS case, the split en banc court can't agree on anything. 130 pages or something like that of opinions. And finally, we have the Supreme Court, where the justices, for the most part, do not seem comfortable with technology or familiar with patent law. So take just 1 minute to suggest some reforms that ought to be considered. One is to enlarge the concept, to broaden, to understand the defense of obviousness more broadly. Anytime there's an invention is the result kind of routine research activities by a firm, it should be regarded as obvious as not requiring patent protection. Another, that presumption of validity should be eliminated. If you want, you can place the burden of production on the alleged infringer to show that there's some evidence of invalidity, but to shift the burden of persuasion and to make it persuasion by clear and convincing evidence, I think terrible mistake. The judges in the pilot program, and I think the pilot program is great, the judges need training. They're not getting training. They need training in patent law and technology. We need, I think, shorter terms for patents, but also variable terms, reflecting, as in copyright law, the fact that different types of technology require different projects. And I think we should consider requiring that patents must be practiced. There must be some product or process, or else it should be unenforceable, and that would cut down on the trolls. So that completes my opening remarks, which actually took a little too long.
Dick, before we turn to Judge Gallarza, I just want to ask you to clarify one thing. Apart from pharmaceuticals and perhaps some other similarly situated industries, would you be just as happy to see the system abolished?
No, I wouldn't abolish. First, one problem is, one reason that I stress the obviousness, dissent, and the presumption of validity is that even in software, even in industries where there, I think, is a great surplusage of patents, there may be, fundamental discoveries with large startup costs that require, that justify patent protection. I should think a shorter patent term with some exceptions, like pharmaceutical patents, would be the first step rather than actual wholesale abolition of patents.
Okay, thank you. Judge Gallarza?
Thank you, Judge. I guess the entire issue of whether or not the patent system is broken is going to be the subject of today's discussion. I suspect that there are some who believe that the patent system is broken and should be eliminated completely. I don't think it's broken. I think it needs to be recalibrated in a number of areas. We need to take a look to see what the actual function of the patent system is all about. If you remember correctly, even Thomas Jefferson was skeptical about the patent system when it was first established. and he was the first patent commissioner. After he finished his term as patent commissioner, he recognized the value of patents. I think the prime objective of the patent system and even the copyright system should be to incentivize innovation. We need to innovate in this country because that's one of the aspects of today's world that we're the leaders in the world, and we export technology. That's our prime element of exporting in today's world. If we stop the incentivizing of technological development, we are going to have a major problem. I think it's also based on our education system too, but that's another time of discussion as to the needs for education. What we really need to take a look at is a number of areas of concern. One, I agree with Judge Posner, there are too many patents issued by the Patent Office. I think many of them are of questionable quality and validity. There is a bureaucratic form of determining success in the Patent Office, and that's by the number of patents that are issued by the examiners. I don't know if that's the best way to do it, but it's been like that since I was a patent examiner back in 1962. I think there must be a better way to do it. Moreover, the aspects of trying to improve the quality of the patents, I think overall the American Invents Act has brought in a new function to the review process, and that's post-grant reviews, which probably will create a better way to challenge the quality of patents being issued. It's going to be an expensive process, but that's one way of proceeding with it. The PGRs, as it's called, will provide people the opportunity to challenge patents even before they're enforced. So from that perspective, I think the quality should be improving. The other area where I suspect we are going to need to focus is the expense of litigation. I was at a conference one time where I suggested that $10 million was not the best way to resolve patent litigation by the expenses of lawyers. And a number of situations that came up, one of the individuals came up to me after the conference and said, "You're too low on $10 million. He was an attorney with in-house in the stent area. He said it cost us $50 million to defend ourselves in that area. And that's very expensive because all of those costs are obviously passed on to the consumer, and that's silly when you reach that particular point in time. The other aspect of it is we need to have a better accelerated system for determining patent resolution, patent claim resolution. And I suspect that some of my former colleagues on the Federal Circuit will very vehemently object. But I always thought that a claim construction resolution right after a Markman hearing would be a good way to resolve the issues on interlocutory appeals in a 1292B. The aspects of resolving the issues as quickly as possible, I think, impacts the cost of litigation as we go along. The other aspect that I think needs to be focused on are damages. What are fair and reasonable damages once infringement is established? I think overall, Judge Posner posed a particularly interesting process of an economic analysis for damages and the incremental value of a particular invention to the item. And if it's incremental, it might be worthwhile to take a look at it. Because otherwise, if you look at all of the patents that are involved in the area of just your IP phone, you're talking about the possibilities of 4,000 different patent items that are included in that technology. Where does that lead us? A $4 million phone? That's crazy. the aspects of impacting the economy from that perspective, I think, is very, very instructive, and that's an area we need to look at. The injunctive relief of patent law, I think the Supreme Court has taken a look at that and imposed some restrictions from the wide-open aspects that were available before, and they pulled that in. The patent thickets that were mentioned, we need to reconsider that. Even the standard-setting organizations that have been established and the FRAND issues that need to be looked at. And I suspect that, and I've been preaching this for many years now, is a tension between the Federal Circuit and the Supreme Court. We have a generalist court at the Supreme Court and a specialized court at the Federal Circuit. The tension is there, but we need to resolve that because, as Judge Posner points out, the Supreme Court is not comfortable with patent law, but they do take these cases. I think the most recent decision that was issued by the Supreme Court was unanimous, 9-0 in the Monsanto seed case. And even there, Justice Kagan, who wrote the opinion, points out in several parts of the opinion that patents are very, very important in our economic structure. So we can't forget that. Moreover, we also need to take a look at it from a legislative standpoint. These are congressional issues that need to be resolved. The courts can't do it. We're not policy-setting individuals. We're not elected individuals. We're appointed individuals, and I think it's up to the legislature to do it. One of the areas that I'm in total agreement with Judge Posner is the fact that we probably need to differentiate among the technologies. We need to have different time periods for different patent technologies. Software, I think, is an area that needs to be looked at. When you have 20-year time period for a software patent, I wonder if it's necessary for that particular purpose. The investment in software development is not as large as it is for developing a molecule for heart control or heart valve or even for the other aspects such as Lipitor drugs and related drugs. The aspects of trying to differentiate among patented technologies, I think, is a very important one, and this is where Congress really needs to come in and take a look at it. So from that perspective, I think the courts can channel it, but it's not up to the courts to legislate.
Thank you, Judge. Paul, Judge Michel?
Well, I think it's important if we are going to consider whether something is broken, whether it's fixable, what particular parts of the apparatus need to be fixed to identify really what is the patent system. When we use that phrase, the patent system, what are we really talking about? I would suggest to you that a large part, the biggest part of the system is actually not visible. It occurs in the boardroom and the C-suite when every day thousands of business actors who are fully informed reach consensual agreements about licensing patented technology so that products can be made and continue to astound us as everything we're carrying in our pockets here today do with their wizardry. What are the functions of the patent system? It said it's to reimburse spent research costs, but I think it's much more than that. It's a system that allows the best informed people, the business actors, to make almost all the decisions. The courts are just the default, where the private business actors can't agree, then in a tiny percentage of the disputes, the courts get involved. It's basically a system that works for business because it's done by business and not by public officials. Secondly, the patent system is a system for sharing technological advances. The single best repository of the march of technology is on the website of the Patent and Trademark Office, where every pending application that hasn't yet been completed is published after 18 months, and every issued patent is published. It's a fabulous device, now worldwide with internet technology for people to track the progress and the direction and the targets of innovation. Third, the system, while it's true that it needs to reimburse people for significant research and development expenses, I would suggest is even more important in its function to incentivize the next round of investment in more R&D and more new products. And that has to come from the allure of future profits, not just to recoup some past expenditure. Now, it's been suggested by my friend Judge Posner that the Federal Circuit is a unbalanced, reflexively pro-patent court. I certainly didn't hear that in the remarks made by Judge Gallarza. It sounded to me like he was either very balanced or mildly hostile to patents. And I would suggest not to be overly defensive of the institution where I used to happily work, but I would suggest that it's a rather well-balanced court. It has many patent skeptics. It has many people who, initially at least, have something of a pro-patent inclination. It has lots of people in between. It has a very rich internal debate. I don't know what's happened since Gallarza and I left. This last opinion was seven opinions. That didn't happen when we were there.
Giants walk the earth.
135 pages.
So I think the important thing is to not overgeneralize. I don't like the word broken because it suggests that an entire apparatus is completely paralyzed and functionless, and that's not what we have. If you think of the patent system as a sort of a large, complicated sort of machine, there certainly are certain gears that need to be oiled and some parts that need to be replaced in order to optimize the efficiency of the functioning of the machine. But the overall machine, I don't think it's accurate or fair to say that it's broken. I don't think it's helpful because it really obscures the more discrete problems. There are problems in the patent office. My perception is they've gotten vastly better in the last 4 years. They've more than doubled the size of the board and brought in enormously talented people of great experience, including senior partners from law firms and people with just extraordinary resumes. They've increased the size of the examining corps from a little over 5,000 to nearly 9,000. They've re-engineered many of their processes. They vastly modernized their horribly antiquated, inadequate computer systems, databases, software, searching machines, and all the rest, which were just awful a decade ago. And they still need further work, but they're vastly better than they were 4 years ago, and they seem on track to continue to get better if the leadership that David Kapos contributed is continued by those who remain behind in the senior ranks, which seems to be what's happening. Now, there certainly need to be more improvements. In Judge Gallarza's day as an examiner, many patent examiners were going to law school at night, and they were studying patent law, and they were focused on law and correct interpretation of legal instruments. A patent's just a legal instrument like a statute or a contract in one manner of thinking of it. That isn't true so much anymore. Very few examiners are going to law school in the process of becoming lawyer scientists or lawyer engineers. So they've lost sight of the importance of careful claim construction and making sure all the requirements of the patent statute are met. Not just that it's not obvious, but that it's enabled to how to practice the claimed invention and that it's fully described so you can see that what's covered by the claims is no bigger than what was actually invented by the inventor. All those things need to be attended to by the Patent Office better than in the past. They're moving in that direction. They have some very good new guidelines. They have some very strengthened procedures for oversight and training on a much better scale than before, but there's certainly a long way to go. In the courthouse, there also need to be great improvements. It certainly is too slow, too expensive, too disruptive, too unpredictable. Trial court decisions are too unreliable in the sense that they frequently get upended in the Federal Circuit. All those things can be improved. Abusive lawsuits can be curbed or punished by existing procedures. The patent statute itself has a specific provision whereby if a lawsuit is completely unmeritorious, abusive, frivolous, whatever we want to call it, the attorney's fees of the other side can be forced to be paid by the bad actor. So we should use those tools more frequently. The judges are being trained. I was in Charleston myself recently with 33 of the judges, mostly from the patent pilot program, being trained by a group of volunteer senior litigators from all around the country, all technologies, law firms, and companies represented. I think that has a lot of promise. Some of the problems with patent litigation are true of all civil litigation. Same thing, too expensive, too slow, too unpredictable, too disruptive, discovery ridiculously disproportionate to the need, and so on. So the Congress and the courts, working collaboratively, I would think, need to tighten up on and reform litigation generally, and in certain cases, special tweaks for patent litigation. Now, Judge Posner has pioneered some very interesting techniques in his forays into the district court in recent years, and I think it's commendable, and I expect that many of his new techniques, some of the things he recommended, special masters and special court-appointed experts and so forth, are being used more frequently than before, and I think that will continue. So I think it's a question of resources and implementation more than the basic design of the patent system, which I think is not broken, but is probably the single best engine the country has to depend on for job creation, increased prosperity, global competitiveness, family incomes, and everything else good that flows from having a vibrant, technology-driven economy.
Paul, let me ask you to clarify one point. You mentioned as a virtue of the system its degree of decentralization, that decisions are made in business offices and not in government offices, and that this is below the surface because it's working, basically. But this is true of the law generally. It's made in law offices, but in the shadow of what the court decisions are and what the law provides. And if that framework, if that legal framework is not well calibrated, it's going to be inducing just a large number of private but very inefficient and costly agreements. So I'm not sure why what you described as a virtue of the system as opposed to simply a fact of life of all legal systems.
Well, look, any system is going to have imperfections, going to have inefficiencies, going to have friction points. This is the real world. We're never going to have a system that's ideal, that's optimal, that's highly efficient, that doesn't have problems. So the question to me is, can we make marginal but significant improvements? If the patent office has a error rate, let's suppose, of 10%, that's pretty bad. That's a lot of patents that are going to create trouble. If that error rate could be reduced to, say, again, I'm just picking numbers, 2%, that'd be pretty good. I don't know very many systems in industry or law or anywhere else that have no error rate or a minuscule error rate at 0.01 or something like that. So I think it would be great if we could get the error rate in the patent office. And by the way, they make errors in both directions. They deny patents they should grant sometimes, and sometimes they grant patents they shouldn't grant. So we should remember it works both ways. Same thing with the courts. The error rate is uncomfortably high. I would say intolerably high. Something like a third of the claim construction rulings by the 650 trial judges spread out across this country get reversed at the Federal Circuit. That's way too high. That ought to come down. There's no magic number. We can't declare victory when it gets to 8%, but 33% is way too high. There's something wrong with the Federal Circuit's guidance on claim construction, where we have for 2 decades now such a persistent error rate by the district judges. So I think a lot of, it's not very sexy maybe to talk about practical improvements in the patent office, in the courthouse, but I think that's where the action is, that's where the potential is, that's where things are getting better, have gotten much better than they were 5 or 10 years ago, are on a pathway to continue to get better, and that's where we ought to concentrate our efforts rather than talk about abolition.
Judge Posner, you referred to, I think you were the first to refer to patent trolls and thickets and so on. And of course, this is very much in the news, or at least the patent world's news, in connection recently with the the so-called smartphone wars of the last several years, in which you've played a battlefield role. But it was also true on a large scale in the 80s when we had the semiconductor wars, and there were diaper wars, I'm told. I don't remember that. Judge Gallarza has referred to the stent wars, which I think he lived through. Before any of our time, there were the similar problems with sewing machines, light bulbs, airplanes, radios, all of which seem to have gotten sorted out. And I wonder whether we're all a little too aware or whether the immediate problems loom larger than they really should. If this isn't just sort of the nature of the system generates flare-ups when there's a major technological turn, and they get resolved and we move on.
Well, I don't think the problems are limited to software. So while there's certainly a strong case for patent protection in pharmaceutical drugs, there are also serious problems in the pharmaceutical drug patent world because of Hatch-Waxman, because of the generics, because of concerns about collusive arrangements between patentees and generics. So I don't think this is just a software problem, nor are the trolls. They don't just bring software. They don't just bring software cases. And as I say, the trolls will be enhanced by this new practice of hedge fund financing of litigation. And I don't know anything about how successful the patent system was in the 19th century, sewing machines and so on. But today, with the extraordinary legal investments in the patent system, extensive patent litigation, the huge number of patents, the complications that creates for search, the fact that, the old technologies of the telephone and the sewing machine and even the airplane and the automobile and so on, they were a lot easier for lay people to understand than modern technology in any field, not just software. So we're challenging judges and jurors to a tremendous extent. It's not clear that these institutions can really handle these problems. But in any event, I don't advocate abolition or anything like that. I think there ought to be. I don't know why I don't know where the 20-year term came from, and I don't understand why there would be a uniform term across every industry in the country, except, there are a few exceptions, mainly pharmaceutical drugs. What's that about? Why 20 years? Shouldn't there be critical examination of whether that term is correct term, whether there shouldn't be more variance in terms? And although Judge Michel pointed out, incremental improvements in the patent office, which is fine, and so on. But what about looking at more fundamental reform, such as the presumption of validity? Is that really sensible? Have a presumption based on a patent examiner's decision? You need clear and convincing evidence to invalidate a patent, and you have all these huge number of patents. That doesn't sound right. And similarly, don't we grant too many patents? Aren't the courts too lax? One of the reasons we're getting a lot of jury trials in patent cases, is that studies have shown that juries really like patents. They like inventors. They think invention is great. And they don't like inventing around, right? Jurors think inventing around is infringement. It's copycatting. Whereas inventing around is perfectly lawful, and indeed it's one of the reasons for publishing patents is to enable inventing around. So the more we have juries involved, presided over by judges who are not aggressive in taking control of a trial, but leave it to the lawyers. You know, the imperial passive role that judges are most comfortable with. I think we have a deteriorating system. I'm not comforted by the thought that we got a sewing machine and a telephone in the 19th century.
I'm told that Judge Breyer in California Northern, on a patent case, will instruct the lawyers to have their client present for the selection of the jury. And when the jury has been selected, he instructs the lawyers to ask the clients, do you really want these people to decide your case? But apart from the pejorative content of trolls, why isn't the emergence of patent aggregators and patent assertion entities and so on, as they're otherwise called, simply an efficient division of labor between those who invent and those who enforce?
First of all, I do not consider troll a pejorative term. Trolls are charming. They're part of, they're part of magic and fairy tales and so on. Trolls are fine. Nothing against trolls. And I've had troll cases. I like the troll lawyers. They're totally cynical. They're very easy to deal with. You know exactly what they want. The problem with the trolls is, look, ordinarily, you're not going to, if you have a product, patented product, you're not going to sue every possible infringer. You're only going to sue infringers who you think represent a threat to your product. But the trolls, they don't make products. They don't have products. So they will send their demand letter to every conceivable infringer and demanding a license fee. They don't get the license fee. They have to sue in a certain number of cases in order to maintain their credibility. What are the trolls doing for the invention system? They're suing on diagrams, right? They're not being used for anything. They're just sitting there, and you can use these diagrams. I had a case in which the troll had a patent on something that no one was making, and the prior art defense of the defendant was also a diagram, some patent they had, which they'd never practiced. So you could imagine a trial of this case. We have no product. You'd have two diagrams. Well, fortunately, it's settled. No, I think the trolls are an unmitigated disaster. I can't see any social purpose that they serve.
So charming but disastrous. Okay, we got it. It's a widespread view. They have very few defenders, I guess. Judge Garza, you agreed with Judge Posner about patent terms being responsive to the needs of various industries. And Jeff Bezos has also suggested 3 to 5 years for software, that sort of thing. But from your experience, would these distinctions involve unmanageable boundary line problems?
I don't believe so, because basically you would have the Patent Office making that determination if it's a statutory determination as to the technologies that would be covered within certain differentiated time periods. I think many of the aspects of trying to come up with a fair number of years for patent protection, one of the animals that we do have here in Washington is called a lobbyist. And almost like the trolls, they become very, very attached to particular issues, and they do have a tendency to represent their clients' interests before the legislature, and that's part of our system. But at the same time, whenever you try to make some basic changes to the statutory scheme, you have people who object to it because They feel that their particular interest is being gored in the process, and this is one of the reasons why you ended up with 20 years. It used to be 17 years from the time of filing. It's now 17 years from the time of issuance. It's now 20 years from the time of filing. And that's another legislative compromise that has come up. I believe that if we had a differentiated basis of patent terms, it would make it much easier for people to protect their interest while it's still viable. There are many patents that are in their last 2-3 years of existence which no one ever enforces. But at the same time, I think if you had a particular system which provided for differentiated time periods, you'd be much better off because you would have the opportunity to recover your investment plus a fair return on investment and to provide for different types of patents. For instance, one of the problems that we've had in the past, even in the medical area, is the protection of molecules, particular molecules, by continuation in part applications and other aspects. So you end up with not only 20 years, but 40 and 45 years of time periods protection for that same particular invention. And that's part of the system, and people take advantage of it. I think if you had a one-term type of a patent where you can recover your investment and a fair return on investment, the economy would be that much better off.
Judge Michelle?
Well, I'm concerned about the use of what I'll call overgeneralization. So when you talk about software patents being bad, I find that a little indiscriminate. Some software patents are invalid, and some are valid. And the same is true of patents in any other technology. Some are valid and some are not valid. And the ones that are not valid should be struck down. The recent statute creates a new procedure back among the experts in the patent office to review, to re-examine, if you will, the validity of patents that were issued, maybe wrongly issued, and strike them down. That system is activated and working, and it overturns the presumption and it just starts all over again. Is it patentable or not? So there's a pretty good solution already in gear. And I also don't like what I consider overgeneralization if we treat trolls, meaning people who don't make products, as one uniform class. All trolls are not equal. Some are abusively asserting patents that are not being infringed or are invalid, but many are asserting patents that are valid and are being infringed. So shouldn't we be measuring the behavior of the patent asserter rather than their business model or their motives or their organization? From the beginning of the country, the decision was made, unlike Britain, to not require that a patent owner practice the patent, and to allow the patent owner to freely sell the patent to others, and for them to sell it to others, and so on down the daisy chain. It seemed to me it's worked awfully well for 2 centuries, and even quite recently. You know, all these fabulous devices we're carrying in our pocket came out of this system. So to say, you know, the system is broken doesn't sound right to me. We've had fast, fabulous innovation in the electronics industry and many others. You know, a lot of software patents are good patents. A lot of trolls, I think, are playing a constructive role. The ones who misbehave should be punished, and they can be punished. So it seems to me if we're going to correctly prescript the cure, we have to accurately diagnose the disease in particular, not with gross generalizations.
Before we
Well, I
turn
want to
this-
challenge
go
what
ahead.
Judge Michelle has just been saying. First of all, I mean, are you really comfortable with the fact that 60% of patent lawsuits are brought by trolls? I mean, isn't this something that might require some study at least to see where there are too many, right? And also, to say that some software patents are good is not responsive to the problem. Should there be 400,000 software patents in force? doesn't that create enormous uncertainty and legal expense and sheer confusion and uncertainty as to what one can do without running into a patent minefield? And I'm very curious what sensitivity, if any, the Federal Circuit has to academic studies of the patent system. There is a very large academic literature by respectable people, economists, law professors. It's a very critical literature on the whole. And the question is, what, if any, heed do the administrators of the patent system, the Federal Circuit and the PTO and so on, what heed do they pay to their critics?
Well, I don't think you can do patents by the numbers. To say we have too many patents isn't to say anything very helpful. We certainly have too many patents that aren't valid, and if re-examined, would be struck down. So to that extent, I think the number counts. But if all the patents that were out there were valid, met every requirement of the statute, I would think that would be a good thing. Really, almost the more the merrier, not the more the worse. It would reflect more patentable inventive activity. And in fact, the application rate has gone up hugely over the last 20 years. And the grant rate is plus or minus about 50%, varies a little bit from year to year. So I don't think it's helpful to say, well, 400,000 software patents, that must be terrible. Well, I don't think so. First of all, they're searchable because of classification systems. It's true that not all the terminology has been uniform from start to finish, but it's gotten more uniform over time. I don't think you can say what the right number of software patents is or the right number of patents in toto is. I don't think there is a right number. The real question is, was there a real invention? Did it meet all the requirements of the statute or even a revised version of the statute? So there's a valid patent. And then the next question is the patent being infringed? If so, there should be some remedy available in the courts when the private actors can't agree.
Well, one of the other aspects.
But look, it cannot be the case. It cannot be the case that 400,000 pieces of software would not have been invented without patentability. Because most of these 400,000 are little tiny, little pieces of code, little tiny incremental improvements that do not require enormous expenditures in order to make. So are you content with having patents granted to people who spend very little money, time, take very little risk in order to create them? If those 400,000 bits of software would have been created without a patent system, then isn't the patenting of those 400,000 simply a dead weight cost?
Well, if the premise is right, the conclusion follows. I'm not sure the premise is right. It's easy to say.
Can you think that all those 400,000 pieces of software had required the kind of upfront expenditures that pharmaceutical drugs require?
It's easy to say all this invention would have happened anyway, but we don't know that. And the people who control the money seem to think we wouldn't have the level of innovation that we now enjoy, much less the higher
What
level
does that
we need.
mean? I don't understand what you mean, the people who control the money.
Well, the corporate decision makers who are going to decide whether to divert a larger or a smaller part of their revenue stream, their profits, toward research and development of new technologies and new products and building new production facilities and hiring new workers, they're making decisions based on whether there's adequate incentive and assurance of adequate returns in the future. So one of the things they're looking at, there are many others, of course, but one of the things they're looking at is whether they can have reliable patent protection and adequate remedies. On the other side, the small companies that don't have a revenue stream are depending entirely on outside investment by venture capitalists and other like investment controllers. So incentivizing those two groups of decision makers seems to me to be critically important. And in a way, the question comes down to whether we want to have the same amount of innovation we have now, or less or more. It seems to me that with the jobs crisis in this country, we need a lot more innovation, a lot more new products, a lot more new production facilities, and hiring of workers, not less. So that makes me think probably maintaining a strong but better, smarter, faster, cheaper, fairer, more predictable patent system is the preferable way to go, rather than to weaken it.
Let's get Judge Gairos in here.
Well, one of the elements that I think is very important to focus on is that even though we might have 400,000 software patents, I don't know the definition that's being attributed to software patents in this particular instance, but when you consider that during the year there are probably only 4,000 to 5,000 patents which are challenged in court, I think that overall you have a large number of patents which are never brought to court. So we have to focus on what really is brought to court, whether it's brought by the trolls or otherwise. Moreover, if you take, for example, one of the most important software patents that was issued to two graduate students from Stanford University in a algorithm to establish page research at that level, that did not take that long. However, Stanford University did have an interest in that particular patent. They own the patent. It's called a Google patent. When Google went public, Stanford got $336 million out of that patent sale of Google stock. Does that mean that that particular return was unfair? The graduate student maybe has spent less than one semester in putting that algorithm together. But it's an interesting process that developed a new industry. Are we going to say that they're not protected by patents because we have 400,000 patents that might never even be enforced? I'm beginning to wonder whether or not the particular system that we have needs to be fixed. Sure it does, but it has to be recalibrated. I don't think we have to just say generically that it's not necessary.
Judge, are you analogizing the Stanford situation to pharmaceuticals because Stanford's running a big research and computer science lab and so on?
No. What I'm analogizing is the fact that that was a software patent, which was a very valuable patent that was developed by two graduate students. And they built an entire industry on that one patent. What other patents?
Well, it's a good example of how 336 million was grossly excessive compensation for them.
Well,
Because they would have built it for nothing, right?
they
It
would
didn't
have.
cost anything to build it. They're graduate students.
It's
It
not
didn't
a
cost
que-
anything.
It's not a question of cost. It's a question of return on a particular invention. If that invention is salutary in the industry, just like Lipitor. Lipitor is salutary to Pfizer, and it's a very important drug for a number of people in this world. Is it
Yeah.
important to protect only that particular aspect of it, or are we also protecting other industries?
No, you're missing the point. The question is, do we need to give these kids 336 million in order to induce this invention? If we don't need that, if we don't need a patent, or we don't, in order to induce inventions, then we're wasting money in paying hundreds of millions of dollars to inventors. That's an elementary point.
But
right?
it's the reaction of the free marketplace that places the value of that particular invention.
This is not a free market. The patents are not the creation of a free market. They're a government monopoly. Now, government monopolies are sometimes granted for good reasons and often for bad reasons.
I want to take this opportunity for those in the room to turn the tables and ask questions of judges. So you've heard a good deal of disagreement and some convergence as well. Many of you came here with your own prior questions, and others have developed new ones in light of this. Sir. Oh, you have to wait for the microphone. There you are. Okay.
Judge Michelle. I thought you had a fair response to some of Judge Posner's questions, but one that I didn't hear you address, and I wonder if you could, is whether you're comfortable that 60% of the patent suits that are brought in the United States each year are brought by trolls.
Well, the comfort level, it seems to me, should reflect the merit of the suit rather than the business model of the plaintiff. If the suit is meritorious and there's a valid patent and it's being infringed and there are real damages that can be proven, then that seems like an appropriate outcome, at least to me. And I don't care too much whether the plaintiff makes products himself or not. I'm not uncomfortable with any particular percentage because I think the main issue is validity and infringement and proven entitlement to remedies rather than the business model of the person suing. Look, I mean, we've made it a property right, a right to exclude. I don't agree it's a monopoly. I mean, a monopoly is something that happens in the market where you can keep out other people or have absurd prices guaranteed. Most patents don't come close to creating a monopoly in that kind of sense. So the word's being used maybe in a little more colloquial fashion. But I think that the important thing to focus on is how to improve the system and not to draw big conclusions from the fact there are 400,000 software patents or there are 60% troll suits or any other number. These numbers don't tell us enough by themselves to give us a good roadmap to significant improvements. And by the way, the patent system is not restricted to breakthrough or so-called pioneer inventions. It's deliberately been crafted from the start of the country for incremental improvements. And in every technology, I'm told by people who know much better than I do myself firsthand, most of the improvements are incremental, are iterative, much as Judge Posner says is true in the software fields. It was not so different from what I'm told in other fields. I don't think it's accurate to say that only pharmaceutical companies really need a patent system. I think it's quite the opposite. Almost every technology needs a patent system. Not every company, but many companies in almost every technology have important dependence on the patent system, so we should make it work better for the benefit of everybody.
Another question?
Well, one of the aspects that needs to be kept in mind also is that trolls, or non-practicing entities, as they prefer to be called, are also inclusive of universities. Many of our universities conduct extensive research centers, and they come up with very large patent portfolios. They're non-practicing entities under that definition, too, because they don't build anything. All they do is research, and they enforce their patents. So we call them trolls. Are they fitting into a particular category that we need to protect or not protect?
Another question?
But they don't mainly litigate. That's not the main thing universities do with their patent collections.
There was Nick Chidiak from George Washington University. There was some discussion of differentiating between different technologies, and Judge Posner mentioned that certain breakthrough technologies would be deserving of patents. Since the patent system is inherently looking at newer technologies, how would we have a system that would be able to anticipate what different technologies would mean years hence? How would you sort of characterize it's, first of all, where would you draw the lines, and then how do you think those lines would actually function in practice?
Judge Posner?
Well, one possibility would be to have a short term, a 5 or 10 year term, and then if that proved to be too short for particular industries, then change it, have some more flexible adjustment of term to particular products. But the alternative is simply to have a higher standard for the grant of a patent. So if you have a higher standard, that will automatically strain out the inventions that do not require patent protection. So Judge Michel said that, well, all invention or most invention is incremental. Yeah, but the critical issue is the cost of the increment relative to the costs of the people who might infringe it. And if your costs of invention are low, and it's not that easy for someone to copy you, then you don't need the patent. And to grant patents that are not used, that just become litigation vehicles, that seems to me very inefficient.
I like the idea of making the standard more stringent. That's what the Supreme Court was trying to promote with the decision in KSR, and the Federal Circuit has followed on with the subsequent decisions. I think the law of obviousness is the heart of the whole thing, and it's been tightened up. It probably needs to be tightened up some more. I think that's a very useful direction to move in. My problem with varying the terms is, number one, I think we've agreed to international treaties along with numerous other countries that require the 20-year terms, that we have to undo a laboriously erected international set of treaties. Pretty hard to do. But secondly, if it's a constantly moving target where every couple of years lobbyists will get Congress to change the number of years for this category or that category or some other category, don't we complicate the decision-making by these people that I'm calling the investment people who control where the money goes for R&D and new factories? Because they're going to have to worry, well, it's a 5-year term now, and I'll start a 4-year-long project, but then Congress 2 years down the road may change the term to only 2 years or 8 years or who knows what. And it would result in endless jockeying in the Congress to control the categorization and the number of years. In principle, it has some appeal, but I think it might be extremely difficult to administer and may expect more from Congress than they can actually be counted on to deliver, judging by what we see every day in the newspapers.
We get another question on the floor.
Thank you. Stephen Glazer. I'm an administrative law judge, and I practiced at the ITC for about 14 years before I became a judge. And a question I have for the panel is, well, why the thing I've always noticed in practice was that the most costly aspect of the litigation were the defenses. There were about a dozen or more defenses to a patent, even though it was presumptively valid. And that's what drives the cost up. So why don't we just create a system where the PTO is kind of like an awarding agency that just awards patents on the basis of certain criteria that it has, and then say that's it, and allow the patents to go forward without any defenses whatsoever. After all, the point of a patent is to license it. So it's just a matter of contractually entering into some kind of license with somebody somewhere else. Wouldn't that avoid the costs of litigation?
Well, you've got the new American Invents Act, which provides for certain PGRs, post-issuance reviews. I think that's a way of scrubbing some of these patents to the point where once they've gone through that scrubbing process, which is secondary and much more focused, before 3 patent judges that are well-versed in the technology, that will provide a patent system, I think, which in some cases, once those particular patents, once scrubbed through the PGRs, the practice will be at least reviewed to the point where they become much stronger patents and much easier to enforce.
You know,
And those defenses, I think, will be brought up before the Patent Office, and once they are rejected by the Patent Office, those defenses will no longer be valid or viable in court because you're just repeating the same process.
The biggest driver of the excess cost of patent litigation is said to be discovery. If discovery can be staged, or if it can be altogether set aside until some preliminary decisions are made, like the scope of protection created by the patent, you could save tons of money and tons of disruption. Judge Posner himself has pioneered some of the techniques to find the sort of silver bullet to kill a patent case, and it might be eligibility under Section 101, it might be failure to enable the practice of the invention under Section 112, it might be obviousness, particularly if that is strengthened, and certainly claim construction can occur with little or no discovery in many cases, I would say most cases. So there are different ways to not have everything run the whole gamut of litigation that runs to $10 or $20 million in all too many cases. So it seemed to me that's an avenue worth continued pursuit to identify the linchpin of the case and bypass lots of the expensive motions practice and much or maybe most of the discovery costs as well. I think Judge Gallarza could sit down with a complaint and a patent and tell you in about 2 hours whether the patent's valid and infringed and what the proper scope of the patent is. If he can do it, other people can do it with a little more training and experience, and then you can short-circuit a lot of these cases. And anyway, 90% of them settle. It's true that the cases that are really huge and go the full gamut run into many millions of dollars, but 90% settle. Lots of them settle early. In my new life, I'm mediating a lot of patent cases, and a lot of it's done at an early enough stage that there's no significant outlay yet for attorney's fees or other costs. So there are lots of ways to address these problems, and I think we ought to utilize all of them to the hilt.
Judge Posner, what's your trial experience with that been, with trying to expedite and cut short some of the procedures?
Well, all you have to do really is set very, very tight deadlines. And I've noticed that the lawyers are very cooperative, and they're willing to foreshorten discovery. And as Judge Michel was pointing out, it depends how early you have the various critical stages, like claims construction, the Daubert hearing, summary judgment motions. As I say, there is a kind of passivity that many judges feel. It's the lawyer's business, the lawyer's case. They play the game. I'm just the umpire. But the aggressive judges are able to compress these costs substantially.
Also, the pilot program judges are all volunteers. I think you can count on most of them to be quite aggressive, and way more so than the average randomly assigned district judge. There's something like 70 of them. They've undergone a lot of advanced training at many different sessions, including the one I mentioned earlier in Charleston. And because they're volunteers and they like these cases and they want to do these cases, I think they'll show the same kind of inventiveness and aggressiveness that Judge Posner's displayed in the cases he's taken as a trial judge.
I should say we've received a few questions from people seeing the webcast that have come in by email, I guess. But I think we've covered those that have come in so far. If others are coming in, we welcome your input. There's a recent working paper from the St. Louis Fed that some of you may be familiar with, done by a couple of professors at Washington University in St. Louis. And I'm going to read you just a couple sentences from the executive summary. A closer look at the historical and international evidence suggests that while weak patent systems may mildly increase innovation with limited side effects, strong patent systems retard innovation with many negative side effects. Weak legislation will generally evolve into strong protection, and the political demand for stronger protection comes from old and stagnant industries and firms, not from new and innovative ones. Hence, the best solution is to abolish patents entirely. Now, I wonder, in your experience, though, whether it's true that it's established firms, for the most part, that are using the patent system rather than startups, new entrants, the isolated graduate student or scientist.
Well, the largest number of patents issued every year for the past, I believe, 8 years has been IBM. And they've been very active in the patent area and establishing, I think, correctly what they've been saying. I don't know what kind of statistics they've used, but I suspect that the peripheral inventions, just like the two young men from Stanford, establishing new technologies are done by the smaller inventors, and much more so because they have no restrictions in some of their inventiveness by having a bureaucrat telling them, well, you work on this particular project today and tomorrow you work on another one. And that's the way most of the research centers operate. But when you have free and footloose individuals that can come up with different types of inventions, I think that also generates protection, which is necessary in the patent system.
You know, Doug, I think, again, overgeneralization is our enemy. Lots of patents go to startups, lots of patents go to middle-aged firms, lots of patents go to huge firms. It's all over the lot. It's a huge distribution. So, you know, the real question is, who's really dependent on the patents? And that's where the startups are really critical. They're the big job creators, according to studies by the Census Bureau and the Kauffman Foundation, and they clearly depend on patents because the people who back them with investment money, I'm told, routinely demand that they seek patents and won't give them the follow-up investment doses until they get the patent. And if those patents are weakened in terms of their enforceability, then it seems to be the incentive to make those investments has got to go down, which will mean in some cases they won't be made at all. So the startups need the patents a lot more than IBM does, and the startups are the last people we want to be inhibiting.
We have another question
Well,
from the floor after Judge Posner.
I wouldn't say that. Could I just comment on
Please
that?
do.
The St. Louis study. See, the problem is that patents have very strong defensive properties, and I think one of the reasons for the software patents, for the proliferation of software patents, is that this is such a volatile industry where firms can be very successful and then collapse because of another, because of a newcomer with a new technology, that the established firms really do want to have a lot of patents so that they can defend against the upstarts. And that's a real problem. I think what Judge Michel just said is widely believed, namely that to finance new operations, the private equity firms and so on are reassured if you actually have a patent. So that's certainly an argument for continued allowing patents. I think abolishing the patent system is not in the cards, so not really worth discussing.
There's another question from the floor here.
Judge Posner, one of the things that I think, I guess to characterize this, I disagree with the point about how much you have to invest being the driver for invention. It's more the driver for distribution. So you have an accidental discovery, and the one I'm thinking of, sadly, is the flux capacitor, where Doc Brown falls down and he invents a time travel device. No investment was necessary in getting that, but there's certainly investment necessary in getting it out to the public. That's the benefit we're looking for. So you need to reframe where the investment occurs. Is that a possibility to look at?
Judge Posner?
Well, that's certainly true. In the case of the drugs, the pharmaceutical drugs, most of the expenditures are on the testing rather than on the actual invention. But they're very considerable to spend sometimes more than $100 million. I think the drug industry actually exaggerates, but you can spend more than $100 million getting your drug approved. And those are upfront costs. You have to recover them. So the important thing, the focus is on the costs that are incurred before you start selling the product. And it's very important that you be able to recover them. And sometimes you really do need a patent, that is, ability to exclude competition in order to recover those costs. I do think it's a rare. It's rare, and that therefore many patents are obtained for reasons that don't serve social ends, but just the private competitive goals of a particular company.
I'd like to ask, we are short on time now, but I'd like to ask just for a brief comment. To the extent that people do not seek patents because of some changes in the under the thresholds for getting a patent, or for because they're categorically excluded for one reason or another, no patent means no publication as well. And so that would seem to be, to some extent, a drawback to others, to innovation by others. Is that a relevant consideration here?
I think so. Lamoureux and Sokolov wrote a book that focuses a lot on this, where they say, look, if you don't have any patent system, or you have a very weak or very narrow patent system, what are most actors going to do? They're going to keep their invention secret to the maximum possible extent. So they won't be published in patents or otherwise, and unless they can be reverse engineered, the new technology won't get out to others to be able to build on, improve, design around, and all the rest. So that's not a very happy prospect. So it seems to me we don't want to go down that road. That's not productive. And in terms of the investment, I'm told by people in the startup world, I have no direct experience in this, of course, that there are often 3 or 4 separate doses of outside investment needed to get the original research up and running, to develop a commercial sellable product. Stage 2 needs a second dose. To build the factory, to mass produce the product, takes a third dose of outside investment, and then to have an initial public offering to tap into the capital markets on Wall Street, you need a 4th dose of venture capital or other such investment, and that each of those doses has to be bigger than the last one, and at each successive stage, the potential investors are demanding more assurance that they're going to get their money back. So it needs a lot of incentive. I think that's what the patent system run optimally can provide, and I don't see any other way to provide that kind of incentive.
Judge Garza, your closing comment, and then Judge Posner's closing comment.
My only concern is that a lot of the statistics that are used are not clearly analyzed in the underlying facts which put those statistics together. Statisticians can come up with just about any kind of a solution to a problem. But at the same time, what we need to do is to focus on the incentive for technological development in this country. And we need to make sure that our patent system is available to protect not only the startup situations, but also the developing situations for further investments. I agree with Judge Michel that the process of developing an invention is not as easy as many people put together. The aspects of trying to come up with a proper solution, I think, is something that we all have to work together and develop a process by which inventors are properly recognized and properly rewarded at the same time for their disclosure, so that we can build upon what's available in the past. Because without disclosure and people keep it secret, it's not a way to develop new technologies.
Judge Posner?
Well, I didn't care for Judge Garzar's comment about statisticians can come up with anything. There's a dearth of data, but in particular, there's a lack of interest in data, and there's too much, seat of the pants speculating about the costs of invention and about so for example, you raised an interesting question that Professor Michel addressed. How much do we lose if we narrow the patent system, and as a result there's more reliance on trade secrecy in order to protect an invention? how much do we lose in valuable information, and how much do we gain by limiting the scope of patents? That's an important issue. That's a studyable issue. And another studyable issue is how much does it really cost to bring these products to market, bearing in mind that a lot of the pre-production, pre-sale expenses are incurred after the actual invention. These are critical questions. Now, they have to be studied. They can't just be waved aside, right? They can be studied. And there is a very large academic literature. And I think it's a serious mistake if the judiciary does not take cognizance of this academic literature and pretend that we know everything because we actually, decide or preside in these cases.
A useful admonition. Thank you, Dick. Thank you, Judge Posner. Thank you all. And please join me in thanking our panel.